within CASA, or indeed for the ATSB, Mr Dolan, that if an employee of CASA or the ATSB is going to go somewhere else for employment, is there a requirement to advise CASA that they are going to an airline, for instance, for employment from the day that they know that they've got that job?
From CASA's point of view, yes, they'd have to declare a conflict of interest.
Right.
Can I just ask a question there? In terms of the exemption that was granted, could you clarify that?
Could you clarify the extent of the exemption grant? I think there's some issue there in terms of Order 48.
For Jetstar, isn't it?
Yeah.
So a commercial advantage to Jetstar?
I don't actually have the schedule that was attached, that would have been attached to this. Here we have it here. No, that's what I've got. I haven't got the schedule that's attached to it.
It's a standard industry exemption.
I think, yeah, Senator, that my understanding is that this was a standard industry exemption, but I'll have to take that on notice, and we will. And your specific question is, did we give Jetstar a commercial advantage?
That wasn't my question, actually.
I'm asking.
Sorry, Chair.
What I'm just trying to clarify is, what does the exemption enable?
This particular document, I'll have to come back to you on that, Senator, on notice.
Do we know? Do we know?
Well, my understanding is that it allows for operations in terms of back-of-clock operations and related matters. That's my understanding. I don't know if Mr Hood wants. I think Mr Hood's nodding his head.
Yeah.
I mean, it's a pretty fundamental exemption, though, isn't it? Yes.
So could you just explain? Is it just the normal exemption, or if it's a normal exemption for everyone, why is it an exemption? And if it is an extraordinary exemption, does it give a commercial advantage? Yeah. And if it gives a commercial advantage, could that be an inducement, the job? To give the commercial advantage.
Chair, we our intent would never be give a commercial advantage. The standard, this is, and I have to confirm this to you.
No, I appreciate that you wouldn't want to give the commercial advantage, but does the exemption give a commercial advantage?
The exemption is available to all the people that are competing in this particular area. So,
and do they all have it? And if not, why not? If it's
Mr Hood's area, I'll just
Senator, certainly the majority, and we're anxiously awaiting the arrival of the ICAO SARPs to review the legislation in this regard. We currently have a civil aviation order which talks about the management of fatigue. We have a general exemption which looks at flight crew duty periods.
So why do we have the general exemption? Because the present law without the exemption is inadequate or out of date, or modern technology has overpowered it, or...
Senator, perhaps I can answer that. Peter Boyd, Exec Manager of Standards. Because it's a prescriptive piece of legislation as it stands at the moment, there are very many situations that it doesn't fit. So over a period of time there have been standard exemptions to that piece of regulation developed to fit different situations that need to occur. So, as Mr Hood has already mentioned, we are eagerly awaiting the ICAO SARP to I suppose, tidy up and move forward into the modern world in terms of that fatigue.
So if that's the case, then Jetstar and Virgin and anyone else that wants this exemption gets it. And have they got it?
That's correct, Senator. To my understanding, they meet the requirements and the safety requirements, and they will be granted the exemption.
There are only three ways, Chair, that you can control flight time limitations at the moment. That's to use the CAO 48, have a fatigue risk management system, or use one of the standard industry exemptions. Now, this standard exemptions, there's an international one and a domestic one. They're referenced in that report, Senator Xenophon, that you have there. Now, we don't particularly like this approach of exemptions to regulations, but they've been around a very, very long time. And, of course, we then have a difficulty if we were to try and remove them. But we will, with the new fatigue risk management scheme, go away from CAR 48 completely. So CAR 48 will cease to exist in its present form.
Sure. Can I look? I'm just looking at the document you've just provided. This is just I don't know if has it been tabled, Chair. It's been tabled, yeah. So this is a document headed. It's addressed to Mr. Bruce Buchanan, Chief Executive Officer of Jetstar, 10th of May 2010, and it's attaching the CASA audit report formalised for Mr. Buchanan's attention.
Correct. That's the document I have.
Yeah. You've got that document back.
Yes, document,
yeah.
yes.
Good. As I understand it, though, it doesn't incorporate the audit prepared by the special fatigue audit. In other words, what CASA got from its auditor, or the audit that was carried out, is not the same document that was provided to. It's not the same document that was provided to Jetstar, was it?
And no, Senator, as I say, the document that's provided to Jetstar was from the audit team. Mr Cook was a member of that audit team for one speciality as human factors.
Well, human factors are very important, though.
I'm not denying that,
yeah.
Senator, I'm not denying that. However, a lot of what is in Mr Cook's report, in the opinion of the audit team when they got together to make the report, and I will point out again that his actual report that you referred to, Mr Cook's report, 10th of May, is dated the same date at which this was done, so his report was brought very late. We're not necessarily, would we ever incorporate every recommendation or finding from somebody, from each individual part.
Sure.
And also there is some question about the evidence that backed up a lot of the allegations or findings that Mr Cook put in his report.
But some of the findings in that report actually said there seems to be a lack of evidence for an appropriate system in place, or, you know, I'm
yeah.
putting it in general terms. In other words, saying, where is the evidence of having a system in place to deal with fatigue? That surely is relevant, isn't it? In the absence of, if Mr Cook could not find any evidence as a result of his audit, then it's not unreasonable for him to put that in his report.
Completely reasonable, Senator. In fact, we would encourage it because it's an internal document that goes to form the final document, but it is not the final document.
But you're not criticising this report as such. It seems to be, given the qualifications contained within it, it seems to be quite robust.
I think, Senator, without having, and I've read it as close as I can, but without having, of course, spoken to anyone involved, if you look at the audit observations in the final report, many of his observations have been bundled together, shall I say, into audit findings, such as or audit observations, not an actual finding. The very first one, reference number 1, talks about flight crew member flight duty, rest time, and incorporates some of this back-of-the-clock flying, as the term is, or more correctly, it's known as operations within the Windale circadian low. The actual rostering, the domestic exemptions, the use of the 48 exemptions are all in this first report here, first audit report. I would say that Mr Cook's report is most probably, and I'm not casting any doubts on the veracity of it, is not in a format where we would give that to an operator.
Yes. Well, Mr Cook, as I understand it from the research I've been able to do, has got a particular expertise on human factors. He's still working in this field, isn't he?
I don't know what Mr Cook's doing now, Senator. I'm sorry.
Yeah, I think you'd find that he's still providing advice at a high level to the Australian government in relation to this. I want to understand this process. I'm conscious of time. You get the input from this audit. You provide the letter to Mr Buchanan requesting that he attend to these matters, correct?
Yes, sir.
How do you know that these matters have been attended to thoroughly? Because, for instance, the information I've received from pilots is that in terms of the extension, in terms of the hours within the exemption, you can get an extension sometimes because there's a discretion there that's referred to in this report. You're familiar with the concept. In other words, you go beyond the maximum hours. The information I have is that 12 out of 21 flights, Jetstar flights, were extended in January this year alone. Are you familiar with that in terms of extensions? I'm
not familiar with that statistic, Senator. But
would you be able to take on notice whether that's the case? Because if there was an extension in 12 out of 21, more than 50% of flights, in terms of the hours, even allowing for this exemption, the CAO 48 exemption, would that indicate some systemic issues that need to be addressed?
If I could talk more on a global issue, the use of flight time limitations and extensions of duty periods or reductions in rest periods, rightly or wrongly, whether it is the right thing to do, it is industry standard. It is not necessarily, am I saying that we should condone it, but it is something which is generally accepted around the world. So I think.
What's the point of having the standard if we're getting 50% of flights are an extension?
Well, because, Senator, and if I could be a little flippant for a second, there's only one known cure to fatigue, and it's called money. And if you pay people enough money, they will work perhaps longer than what they would otherwise do. And generally, extensions of duty incur penalty rates on the company, and they are quite punitive. Now, I can't say that's the case in Jetstar, and I'm not saying that's the case everywhere, but there is always a commercial aspect to this. One of the things that we have to do as a regulator, and also if one is in management of an airline, they should be cognizant of the fact that sometimes you have to protect people from themselves. And sometimes these schemes can be abused from both sides. They can be manipulated, particularly for financial reasons. Now, I think fatigue is the most serious issue that we're facing outside of automation in aviation industry going forward.
One of the judgments in fatigue is what you do in your time off, whether you go and get on the grog or you chase women or, you know, you belt the kids or, you know, play soccer or... I mean, surely this is a vagary. I mean, the exemption that's given, is that to enable competition with people who expect people to work 20 hours a day? I mean, I used to drive a track for 20 hours a day for 3 months in a row and just thought, oh, that's what I've got to do, and I do it. So if I work for Garuda Airlines or someone, do you know, to enable competition, we've got to give this exemption?
No, I think, and I appreciate what you're saying, Chair. I think that the issue is that the original CAO, when it was written, did not contemplate things like ultra-long-haul operations, multiple crews, multiple sector operations, relatively tight turnaround times. The reg's just not up to it. The exemptions were a blunt attempt to allow those sort of operations, which Australia needs because we're so far away from anywhere, really, to operate internationally. Those exemptions were put there to allow Australia's aviation industry to continue to operate. Now, as soon as you put a regulation there, as we all know, it's open to abuse and it's open to interpretation. Our job is to try and stop that.
Look, Mr McCormack, I need to clarify. The 12 out of the 21 extensions for January, that applied for the Darwin-Singapore Darwin flights. So that's just that sector, which was the subject of, you know, the back-of-clock operations. Now, does that indicate to you abuse or verging on abuse if it's 12 out of 21 occasions in 1 month alone?
What I would say, Senator, is it sounds like a very high percentage, and what we will do is we will, because we don't have that data, we will go and I'll take on notice what's happened there. Right. Would I say that 12 out of 21 represents a danger? It could, and I'll stress it could.
No, I didn't actually ask that.
I'll take that word back. Does this seem an anomalous situation?
Or an abuse of the system? Or
an abuse. It could be many factors that have led them to this situation to get that number. But the most common factor would normally be that the amount of time it takes to actually do the mission is insufficient in the planning stage to what it is in the actual stage.
40-minute turnaround at Changi seems, you know, very ambitious.
Well, Senator, we used to turn around 747-400s at 40 minutes at Changi.
Really?
In my previous company.
But even now, even today, with the current loads?
I think Changi traffic's down 1.6% since 2006.
Yep.
In cargo anyway, perhaps not in passengers. But you're right, so the tight turnaround times are an issue. They always
was that a cargo operator you were working with at the time? Or?
That was a passenger operation.
Passenger operation, sorry.
Industry standard is an hour to 70 minutes for a large aeroplane, not a little aeroplane like an A320 or a 737.
Sure, okay.
But there is always going to be this concept that that there's low cost, the low-cost airline. Well, that's actually a bit of a fallacious term because most costs in the airline business are fixed costs. Leasing prices are fixed, fuel's fixed, landing fees are fixed, parking fees are fixed, maintenance costs you a certain amount. So if you wish to pursue that model